Join us in the most unpredictable race. Play for
at about 10. Today is this court, accompanied by the anointing. Is a very deep fear for his life. He expressed, yes. And therefore, because I would like, and I request this honorable court to grant the family and myself, we have all met in court when I was meeting him, to grant time for us to be able to talk to him in confidence and in privacy. And since he still appears to be very traumatized, we urge that any time in the course of next week, we'll be given an opportunity to come back to this court, accompanied by him, so that he is able, and ourselves we are able, to be of further assistance to the court. I regret the fact that I cannot be of further assistance at this stage until we have had a proper session with the anointing area to know exactly what was happening during those traumatizing events. So that's all, my lord. My lord, Mr. Diamois, please stand. That is Mr. Diamois.
Make your way here.
Make your way here.
Lord, as makes his way here. Just for clarification, and what my learned senior was talking about, the affidavit indicates that the deponent was contacted on Tuesday, not yesterday. So for correction of the record. Yes, Mr. I've seen what you say. Allow me to record you.
Yes, Your Honor. In any case, it's clear on the basis of the affidavit itself.
Yeah, that's what I'm saying. I've seen it. So what were you saying?
I was just pointing out that correction.
Second petition. Contacted William.
On Tuesday evening.
Tuesday was first.
Yes. The first of July. It's correct.
My daughter, you appear to have beards. You can take your seat. So who else wanted to say something? Petitioner's counsel?
My lord,
still, now that the DCI is here, there are issues about because these cases are becoming about modus operandi because these cases are becoming so many. And directions of this court, after listening to the answers the DCI may give, may help save the court the time we have spent. So we are seeking your indulgence, but now that the DCI is here, we at least can deal with matters of compliance today. And any other procedural issue we can reach clarification from the DCI. I want to say an application like this comes to court for the rule of law and for the safety and well-being of everyone. So we'll be happy to proceed with the DCI.
Senior counsel, I look at my directions. I want us to look at it. You are very clear.
I have a copy.
Yes, you are very clear on what I wanted to say. We are here only for one subject.
I'll read number 5.
I'm aware. I'm aware of my directions. I'm looking at the subsequent directions that I should last time we were here. Why I need them. Why I need them.
Okay, yes, I'm seeing now number 5.
So can you go
This is
beyond
not the one. So the one
Mr.
exactly.
Kibe?
Yes, Your Honor.
Can I go beyond what I wanted this morning?
I believe that whatever he has done is subject to the directions that were made, but I cannot say.
Because you've made a specific request
Yes, I have.
and you want to participate.
Yes, we have. Yes, but the petitioners can speak for themselves.
I agree.
Yes.
I have the petitioner, second petitioner in court.
Yes, the second petitioner is in court.
I wanted him dead or alive.
Yes, that is.
I have him alive.
Yes.
What else do you want me to do? Once I have him alive. You have requested a reviewed time with him.
Yes.
And it's important. So, senior counsel, I think I'm not deciding. I think the fairest thing to do is to allow the family and you lawyers have a conversation with the second petitioner. And then after you have that conversation, then we will decide how to proceed next. My intention this morning was to have him, and I have him. So I present him to the Kenyan, and he's here in alive. So any other thing is now after you people take the question. Am I right?
We are most obliged. It's just that we thought we could take advantage of the presence of the DCI because apart from that, there were compliance issues. Let me just finish. There were compliance issues which we raised on the
We are not doing the petition. I still have the petition to dispose of.
Okay, then with that I will see.
We are the preliminary stage, we are looking for him, we have to.
And we are relieved.
So can we still have a petition to do, Mr.
Yes, my lord. In fact, my lord, we still have a petition to do.
Yes.
And in the interim of that application, we are relieved that the second petitioner applicant has been found. From our position today, we have come to dine, and our friend is here. And we object. I'm saying, my lord, we had come to dance. It's our work as lawyers and our witnesses in court. We may miss this opportunity. It is a golden opportunity. I am reading this in line with what was found in by your brother Justice Mugambi in petition E436 of 2024 and your brother Mwamuye in E0714 2024 that orders of the court are not pious orders. They have to be complied with. Now that the director of criminal investigations is here, there are many questions that we may need to ask to prepare ourselves in the debrief that we will come to explain to court. He may elect, as we have seen before, my lord, on the day when, and his brother, Mr. Masegeni is here, on the day when the court wants to exercise its prerogative power, the petitioners are usually found. It is a modus operandi. Every time when they are almost getting to the Supreme Court, the petitioners are found. Now, since the director is here, my lord, we intend.
No, I will give direction.
Yes, my lord.
You are making requests.
Yes,
I will give direction. But I want first to take into account the request of the family. Yes. It's paramount to me.
Absolutely.
We want to talk to the second petition. We still can ask him to come. And if you want to ask him questions, I'm here to see.
And your directions, my lord, are very well noted and complied.
No. If you want, he's here. And I'm here.
My lord, just if I may be
So let's have it in order. That we have the DCI, we have the petition. Right? The person I wanted.
Yeah.
You want to ask him questions? He's here. Not tell you no. I wanted to agree how we proceed. As the family have first opportunity to talk to him, there may be something.
I'm actually drawing from your wisdom, my lord, that in this particular instance, as we left last time, the primary concern was the life liberty of the petition, second petition, and we are glad that he's here. The life is breathing. At this point also, Mr. Min has acted complying with the orders, is here. And on the petitioner side, we were ready to cross-examine him. But the family made a request, which is also reasonable. We have a traumatized citizen who, for all intents and purposes, maybe in a day is not even fully understanding what we are saying or going through. The request to debrief, give him time to compose himself, to understand the circumstances under which it could be traced. Then we reconvene. Once the second petitioner has been briefed with counsel, probably gotten medical attention, and is ready now to participate in the petition, all parties come back here. And my lord, the only point you are stressing, which now I'm guided again by your counsel, is the presence of Mr. Amin. We may need him. My vice president, I as deputy designate, vice, would have wished it happens today, but in the circumstances, it may not be possible.
Oh, he's here.
No, I'm talking of,
And we are here.
and I was going to say, my lord, I was actually coming to that. And also recognizing that he's in charge of criminal investigations in the entire country. And getting him is sometimes difficult. And now that he's here, at least to the extent of the first petition as cancelled, we can take our bite at the chin when it is still fresh and here. And we question him, we preserve that we don't fall of instances where when we seek him to come to court, he says he has gone for an operation in Paraguay. Which may be a genuine operation or not genuine, as sometimes happen. So having blocked his diary for today, no prejudice will be suffered if we proceed with him today. But if the court is minded to consider the family request, we'll equal together. And also, my lord, of import in this particular instance that we don't lose focus on.
Yes.
In the replying affidavit signed by the respondents in paragraph 20, the question,
I have which have to.
the affidavit sworn on 30th of June 2025 by Samuel Iteg.
Paragraph 20.
Paragraph 20. There's a live issue which I will not wish that will be lost over. If the second petitioner were to leave court today, there is a real danger that he may be arrested or detained by the respondents. On his behalf and in the interest of justice, I pray that when the court is making directions as regards to the second petitioner, the court consider issuing an order restraining his arrest. If any arrest ends up in court, and he can be bonded to attend to this court when required, so that the question that should be of a primary concern at this point is him getting medical attention and social support.
In fact, my lord, will be happy if the director will just tell us that we will not arrest him. That we go just probably just also for the court to feel the presence.
I confirm the application for protection of the second petition at this time. It is also one we are going to make, so I had to take it in giving its directions.
Yes, Mr. Victor.
Yes, my lord, thank you. My lord, I have an application to make. First application which to make, my lord, is that the court will be gracious to summon the diplomat who swore an affidavit in support of the petition, one Florence Muturi, to attend court during the next hearing for us to examine. Because, my lord, there are certain facts that should be divulged to that have led us to this. There are two affidavits. The first one was sworn on the 1st day of July 2025. 2025.
Which date?
1st July 2025. And there is another one sworn on the 24th day of June this year.
So, Mr. Victor, you should begin sequentially. Hurry up to the latest.
The first one is on
24.
24th. day of June 25.
First,
Yes, that is the first affidavit. The second one, my lord, was performed on the first day of July 2025. Both in support of the petition and the motion.
yes.
Secondly, my lord, in terms of the directions of the court, Lord, now that the DCI has come, once it was summoned, pray that those directions be discharged as regards the appearance of the DCI. And thirdly, my lord, the DCI, in light of what has been stated, wish to be given an opportunity to speak on behalf of the directorate. Because
To have an opportunity.
to address my lord on behalf of the directorate, because they feel that they have not been treated fairly as regards this case, and they need to be heard. An opportunity to be heard as regards all the issues raised. My lord, fourthly,
So I didn't get you.
yes, my lord, he wishes to be heard. Wants to be heard.
Today,
Today, my lord, before you, now that you've summoned him, wants to be heard because they have not been treated fairly.
they say so.
Yes, they need an opportunity to state the facts. Hello? An application has been made orally. I am not privy to the basis of our application.
Which one?
The one for, there were several applications made by Mr. Kibe and Mr. Okabata.
Yes.
Yes, and Mr. Willis Otieno. I pray that we make a formal application so that we have an opportunity to respond.
You are mixing.
My lord, I've addressed you
Let me
first.
see whether we are speaking.
Correct.
Mr. Kibe made a specific request on behalf of the family that there would be one time with the special petition. That's number one, and that's the primary application I have for Mr. Kibe. So what do you say to that?
My answer
Don't
is
mix his
yes.
and the other people.
My answer is simple. Mr. Kibe is not a party in this proceedings. He is not a party in this proceedings. I have no problem with him meeting the second petitioner in whatever capacity. But he is not representing any party in this proceedings. If he was, I would be in a position to respond to an application made by a party.
So you're not able to respond.
My response is Mr. Kibe is not a party in this proceedings. He cannot make an application in proceedings that he is not part. There is the application made by Mr. Willis Otieno. And I believe, Lord, if you look at the notice of motion, filed by the petitioner.
Yes.
There is a prayer that was sought for the unconditional release. And prayers of habeas corpus, Lord. Look at prayer 8, Lord.
That's in the original motion.
It is in the notice of motion, Lord, the one that gives direction.
Yes.
Dated 24th of June. You've seen it, Lord?
Yes.
Yes.
Which one are you referring to?
I'm referring to prayer number 8, Lord.
Yes.
Prayer number 8. So that, my Lord, this is the prayer that has been sought. We have responded to this motion, Lord. And we are ready for it to be urged, Lord, inter partes. And I believe it is only fair that we deal with this motion, Lord, before we consider any other oral application. I believe that you're coming for directions, Lord, so you can give directions over here so that we conclude with this interlocutory application. And that is my brief response.
My Lord, in response,
Before you respond,
yes, my Lord.
I want to find out whether I got Mr. Peter. What you say, Mr. Peter, is
Yes.
that you want the DCI to be allowed to speak.
Because you called it.
Because,
Come on,
yes, yes. I'm not saying I just call you. Why are you here?
Yes.
That's all I want to hear.
Yes.
Because the petitioner, the family has a specific request. The petitioners, counsel for the petitioners have their way of looking at things. So I want to know whether you agree that we hear it, despite the request from the petitioner's family.
Despite the request, my Lord, because of the schedule.
So I have no problem. I just wanted to know whether that's the way you want us to proceed, so that I give directions.
Yes, please.
Mr. Mugabe?
Yes. My Lord, first of all, it is very strange for the Honorable Attorney General to present to the Attorney General the Constitution in Article 166 of the Constitution, I believe sub-article 6 talks about the Attorney General shall promote, protect, and uphold the rule of law and defend the public interest. This is a habeas corpus application, the subject matter of the petition.
Yes.
In a habeas corpus application, and by the nature of habeas corpus, the family is a necessary party, and invariably habeas corpus application are instigated or instituted at the behest of the family. Therefore, for purposes of these proceedings, where the second petitioner is indicated as NDIANG'UI was not there to give instructions, that should be construed as the family of NDIANG'UI. So the family of NDIANG'UI is already a party. And if it was not expressly, it is a necessary party whose right to participate is inherent in the nature of happiness. But if, for whatever reason, it is necessary to comply with technicalities, notwithstanding Article 159 of the Constitution, that litigation, particularly under this jurisdiction, shall not bear regard to undue technicalities. I wish, pursuant to Rule 10, Sub-Rule 4 of the Mutunga Rules, to make an oral application for the family of the second petitioner to be added to the proceedings as a third petitioner. But the primary position is that they are already parties if the second petitioner is a party. My Lord, and that is pursuant to Rule 5. Is it Rule 5? Rule 5 of the Mutunga Rules. That this court has jurisdiction under those two rules, 5 and 10, to make such an order. And my Lord, the last one is a question of common sense and propriety of proceedings. The notion, as urged by the Attorney General, that you can have proper habeas corpus proceedings in which your lordships can lock out the families and their representatives from speaking would be completely unusual. The only issue that we need to clarify is that when I advised that Lilian Wanjiku Gitonga to file an affidavit, I advised that she would come as an interested party. So for purposes of Lilian Wanjiku Gitonga, who gave us the information, will appear as an interested party. But now that he is there, and when we speak to NDIANG'UI, the second petitioner, then we would be able, for purposes of completion of the habeas corpus proceedings, to be of further use as unlitigated to the court. Because all of us, even out of curiosity, want to know where was he? And why has he also disappeared the day before? We want to know that also. If nothing else, for purposes of curiosity. Therefore, we need to talk to him, as we had requested, but we can formalize the proceedings because we need to apply for his protection. We must apply for that.
Do you have a right to reply on my application?
Which one?
The question of the liberty of the individual and the need for him to be given an opportunity to get medical attention. He looks physically traumatized. I'm not an expert, but applying my elementary knowledge of
So
myself.
if you continue talking, he wants medical attention, what are we going to do?
That's exactly what I was going to say, that we should not talk too much, but we should by issuing the order that allows his liberty and will continue to access medical help.
Where I am, I think we are losing the point. I have the DCI report. I have the petitioner report. The family has requested to have a conversation with the petitioner, second petitioner. I have parties who want to keep us here. We want to hear the DCI, Mr. Peter says they were not treated well, he will tell us. The other side wants to examine the DCI. So how do we proceed? Which one should we give preference to? It is something, a decision we have to make conscientiously. If the health of the second petitioner is primary, or do we keep the DCI here?
My Lord, I think we should give way to the family and parties. Those who are needed by the court can come on the next date. The application was about the well-being of the second petitioner. And I think in all fairness, we ought to give way, even though we were rallying to go, we should hold our breaths.
Mr. Vista,
Yes, Lord.
how many documents do I have? I have 3 affidavits from Willie. Is it Mr. Is one third second attendance password that you really that's good. It seems to be the same.
No, my lord, the first affidavit is by Samuel K.
That I have.
Yes.
That's the original.
Yes, that's the original.
That one we have.
Then we have a second, a further replying affidavit by Leonard Seattle. That one is sworn on the 2nd day of July.
So is that one of William?
Yes. So there's Leonard Seattle, and then there's Patrick Will.
The first one is?
The first one is by Samuel K.
Yes.
That is the first one.
Yes. Yes.
The second affidavit is by Leonard Seattle.
Not have that one. The third
one is by Patrick Will.
have 3 copies by Patrick Will.
Maybe they printed the same thing. But we supply, we have copies of it.
Let's check. Did you upload the one on Seattle?
Mr. Marwan actually uploaded it. He's here, I can speak for himself. He personally uploaded
No, you are now the lead.
it. Yes, ma'am.
I told you are his senior.
Yes, and I trust him.
So how do you throw it back to him? Because the one, I'm looking at the system.
Yes.
It is the same affidavit by Guire that was uploaded. It was uploaded twice. Someone else who can assist me, maybe we are wrong in this time.
There is I've given a physical copy right now.
No, it has to be here. So this is the file. Your people can upload it now. Let's see have you seen the one by 7?
Yes, my lord.
The one by 7. You don't have it.
Well, he can re-upload it. So we don't-
Yeah.
We are still trying to confirm what the systems are. Yeah, it's here that you uploaded it twice. I'm sure it is because of the address. So anything else?
I wanted to address your question on an issue that Mr. Peter has raised that my senior Mr. Kuperi, I see is important as better. He's 38 years in the profession alone, and to me, that counts for something.
Please, my lord, leaving what my vice president said, I am the second senior most after senior counsel Karoa. I just wanted to bring the context on the 4 applications made by Mr. Vita. The first one was on the summary of the CEO of the Law Society. I appeared for, together with the rest, for the Law Society and the second petition. As to that application, the Law Society has no objection in respect of the first application by Mr. Vita on the question of cross-examination, which can be dealt with at the appropriate time. What I am worried about are the second and third applications by Mr. Vita because they go against each other. The second application was to discharge the personal appearance of the DCI. But the third one is to give him an opportunity to address court, which is sort of supporting what my other learned colleagues had said about having a bite at the cherry today. So that third application also supports what the other parties were saying, that he can be able to say something. He cannot just say it and go. He may have to be asked some questions in relation to that before his discharge. So while dealing with those 2 applications, you may have to consider how to balance the 2 of them in relation to having given him the opportunity and then thereafter discharging him and whether he will be cross-examined. Then as to the question of a formal application being filed by Mr. Kibi, I think that has been addressed, and that was the 4th link of Mr. Vita's application. So those are the 4 issues I wanted to bring to context for purposes of then when your Lordship is giving directions, then you can be able now to balance what Mr. Vita requires, what we also require, and the fact that at a later stage, since the other affidavits are supporting the petition, they can be dealt with in the main petition, and the deponents, including whoever may be required, a notice can be given as is required by law that we will want to cross-examine you on these allegations or these depositions in your affidavit dated this particular day. That will be all.
Let me make it clear that the court is never addressed. It's the lawyers who address the court on specific items. So if the DCI wants to speak, we will take to the witness box. He's here as a witness of the court. He's led what he wants to say, and then he will be subject to cross-examination.
Thank you.
Those are the directions. If we are going that way, we clear the way for that. Bearing in mind, I have a specific request from the family.
Yes.
So if you want us to go that way, we'll take the stand, be led for the reasons that the court directed you to hear, nothing more.
I think my learned senior, my learned counsel can be able to now.
So you look at the directions that issue, you will be here for a specific mission. We are not addressing any other issue. If we are sticking to that, that's what we are doing.
Yes, but let me address you on that, because I received some instructions. He says he wants to respect the issues of the family. Now that he has answered from the summons of the court to appear, and the second petition is present, that you're discharging, because that two summons have been raised.
What is he telling you?
No, he's telling me to abandon the other applications, my lord.
It's already on record. And all on application is already on record.
So as regards to this time, my lord, is that in discharging, doesn't wish to pose the wish of the family, or someone's actually expired.
A lot of that application, Mr. Bita, I hope will be given an opportunity to reply.
Mr. Bita, you have filed all you have filed in response to the petition.
To the petition, no. I was just dealing with this aspect. Because you know there are other parties. The accusation against other parties.
So you have not filed responses to the petition.
As regards the other parties, but as regards the IG, the DCI, both in their public and private capacities,
You have filed.
Yes.
And those are the primary parties.
Those are the primary parties.
So my concern is there any other thing you want to file in form of a response?
I will file grounds of opposition in on behalf of the other parties that are not primary, is the Attorney General and the Cabinet Secretary of Nigeria. But today is Thursday, by Monday on Friday.
I'm suggesting that we go directly to the petition.
That is okay.
You agree? Petitioners?
We're fine with that.
No, I can also file an appeal.
That's a response, Mr. Speaker.
Yes.
Ask Mr. Brown to come to my case so often. He knows our responses to the petition.
I'm not a bit your court longer than Mr. Maro.
I don't know when last year. But I'm sure you know.
Yes, Madam.
So, next week, so I can give you 7 days?
Yes, Madam. That will be okay.
Senior counsel, I restrict submissions to 10 pages. How many pages would you want to have?
I think then
10 will do.
what do yes?
We are
What
dealing with
one,
the petition because there are specific issues.
then make it maybe 15, yeah.
Mr. Peter, would you still be out?
More than that.
My Lord, before you give your directions, perhaps you consider that the case be disposed by both submissions and viva voce evidence, because we still have that cross-examination.